All right, let's break down a classic bar exam question. We're going to do a postmortem on a total corporate catastrophe and see just how a tiny company can create a legal disaster of epic proportions. Let's dive in. So, you've probably heard a story like this before, right? A few people have an idea, they start a company, and then it all just goes completely off the rails. Well, this hypothetical company, Tesco, is pretty much the perfect example of what not to do. Okay, so who's who in this disaster? We've got Amy, the president. We've got Ben, the secretary. They're both directors. Then there's Carl, just a shareholder. Now look at that investment, $50 each. Seriously, keep that number in your back pocket. It is going to be a huge deal later. And finally, we have Examco, the poor, unsuspecting client who was about to have a really bad time. Okay, here's how we're going to tackle this. First, we'll ask if Tesco, the company itself, can be sued. Then we'll look at Amy, then Ven, and then we'll figure out what happens to all the shareholders. Finally, we'll wrap it all up with the big takeaways for the exam. First things first. Examco is furious, and they want to get paid. Their first target, obviously, is the company. But this brings up the most basic question of all. Was the contract that Amy signed even valid in the first place? Did she actually have the power to lock Tesco into a deal? To answer that, you need to know about authority. And here is your first big, shiny term of art to memorize for the exam: actual authority. A president of a company almost always has implied actual authority to sign contracts that are, part of the company's normal business. She's the president of a market survey company, and she signed a market survey contract. I mean, come on, that's a textbook case. She had actual authority. But even if there was some secret internal company rule that said she couldn't sign it, the court has another way to look at this. And here is your second term of art for your flashcards: apparent authority. This isn't about what Amy was told behind closed doors. It's about how things looked to the outside world. Tesco called her the president. That's them signaling to everyone, hey, this person speaks for us. Examco reasonably relied on that title, so the company is bound, period. So the bottom line here is pretty simple. Amy had both actual and apparent authority, which means the contract was rock solid. When they tried to just revoke it, what they really did was breach it. So is Tesco liable for damages? Oh yeah, 100%. The company is on the hook. So we've established that Tesco is in deep trouble. But what about Amy personally? I mean, her signature is on the contract. Can Examco go after her personal bank account to get their money? Well, you might be surprised. To sort this out, you need another key term: implied warranty of authority. It sounds way more complicated than it is. All it means is that whenever you sign a contract on behalf of a company, you're making a silent promise, a warranty, that you actually have permission to do it. If you're lying, then you can be sued personally for breaking that promise. So what does that mean for Amy? Well, like we just discussed, she did have authority. Both kinds. So she didn't breach any warranty. She made a promise, and she kept it. That makes the contract Tesco's problem, not hers. Amy gets to walk away clean on this one. Okay, so Tesco's liable, Amy's in the clear. But we're forgetting about Ben, aren't we? The guy who came back from vacation and blew the whole thing up. He wasn't part of the original deal, but his meddling is what caused all this damage. And that takes us out of contract law and into the wonderful world of torts. This brings us to a huge one. It's a mouthful, but you absolutely have to know it for the bar. Intentional interference with contractual relations. It's a whole separate legal claim designed specifically for people who meddle and cause a contract to be broken. You could put Ben's picture right next to the definition in the dictionary. So how does Examco prove it? They just have to tick 4 boxes. 1, was there a valid contract? Check. 2, did Ben know it existed? Check. 3, did he intentionally persuade Amy to break it? Double check. And 4, did Examco get hurt because of it? You bet. That's a slam dunk. Ben is in some serious trouble. Now, let's put these two side by side, because this is a really important distinction. Amy acted properly, with authority, to create a corporate duty. Ben acted improperly to destroy that duty. See the difference? Amy's actions create liability for the company. Ben's actions create liability for Ben. So at this point, Examco has a winning case against Tesco and a winning case against Ben personally. But there's a problem. The facts tell us Tesco is broke. Winning a lawsuit against an empty bank account doesn't help anyone. And that brings us to the final, most dramatic question in all of corporate law. Can Examco just ignore the corporation and go after the personal assets, the houses, the cars, the savings accounts of Amy, Ben, and even Carl, the guy who wasn't even involved? This is where we talk about the famous corporate shield and whether a court is going to let you hide behind it. Hey, remember that number I told you to remember? $50. They started this company with a grand total of $150. And even worse, the facts say they were pulling every cent out of the company as soon as it came in. To a judge, that doesn't look like a real business. It looks like a shell game.
And this leads us to our last and arguably most important term of art, piercing the corporate veil. Sometimes it's called the alter ego doctrine. This is the nuclear option. It's when a court says, you know what, this corporation is a sham. It's just the alter ego of its owners. It's their personal piggy bank. We're going to disregard it completely and hold the owners responsible.
So what makes a judge do something so drastic? Well, they look for factors like these. Was the company started with basically no money? Yep. Were the owners draining all the cash? The facts say yes. And would it be completely unfair to leave Examco with nothing? Absolutely. Tesco is basically a textbook example of when a court will pierce the veil.
Now listen up, because this is the point that trips up so many people on the exam. You might be thinking, but what about Carl? He was just a passive investor. It doesn't matter. When the veil is pierced, it is pierced for everybody. Carl took those cash distributions, right? He benefited from this shell game. So when the shield shatters, he's going down right alongside Amy and Ben.
Okay, we have covered a lot of ground here. We've looked at contracts, we've looked at torts, and we've looked at the very nature of the corporation. So let's put it all together and see the final verdict. Here's the final scorecard. Tesco, the company, is liable for breach of contract. Amy, the president who acted properly, walks free. Ben, the guy who meddled, is personally liable for his tort, and all three shareholders, Amy, Ben, and Carl, are on the hook for the company's debt because a court is almost certainly going to pierce that corporate veil. It's a total disaster. If you remember just one thing from this whole breakdown, make it this. The protection a corporation gives you is a privilege, not a right. It's a shield to protect your personal assets, but the moment you start treating that company like your personal piggy bank, a court can, and probably will, take that shield away. So I'll leave you with a final thought to chew on. Looking back at this whole mess, what is the single most important thing these founders could have done differently to protect themselves? What one fact could you change to save them? The answer really gets to the heart of what it means to respect the corporate form. Thanks for working through this with me.